Sorry, who filed any new documents? New documents? Petitioner sir had filed.
During pendency of this CRP, they submitted the application before the head GB by seeking some instruction, and that instruction has been brought in here.
Yes. Now that
Need to contribute and
No.
to reply.
Your Lordship, pleading has already been completed. Your Lordship will see my reply was filed in the month of April, Your Lordship. Since then, there is no prayer as such for filing of any of the documents. Now, with this regard, Your Lordship, why this document was brought into court's notice was that there was an allegation that certain documents were brought into court's record that some of the Gambura who assisted the head Gambura had given a written statement that they have received the notice on certain point of time, Your Lordship. During the pendency, we have approached the Gambura wider application that such and such allegation has been made in their reply, Your Lordship. And therefore, we were given by the head Gambura, he has submitted he has answered to the questionnaires, Your Lordship. That's it. There is nothing new document as such, Your Lordship. And Your Lordship will also see
that the matter has been pending after her reply. Reply in affidavit in reply. So till month of April till 2024, you're almost about to be 1 year, 10 months.
yes.
So long.
That's why I'm seeking 1 week time.
No, there is
In the next week.
what my objection is, Your Lordship. Your Lordship will see that a petition has been filed, an objection has been made, and we have filed our reply, Your Lordship. If they have any other additional documents, they would have filed it way before, after our reply has been filed. We filed our reply in the month of April. Thereafter, they have, and with the consent of both the parties, this matter was fixed for admission hearing. And therefore, this matter has been come up for admission hearing on several occasions, Your Lordship.
Now here
There is,
also-
the pleading has been completed and that was submitted by them itself, Your Lordship. And both the party had agreed for hearing of this matter. And why the urgency, Your Lordship? Even though both the parties had taken time on their several occasions due to some difficulties, Your Lordship, why there is an urgency, Your Lordship will see. After the granting of interim order, Your Lordship, on the next day, they have, without complying to the interim, Your Lordship, we have given the same to the police and to the head Gamburas also. They have already divided the boundary and marked their boundary by a barbaded wire, Your Lordship. We did not come for the contempt because at that point of time, Your Lord, the urgency was shown to the court, and the Honorable Court was had therefore fixed this matter for hearing, Your Lordship. And the only prayer here is to get the case back to the Kaba, who the original jurisdiction has, Your Lordship. The first complaint, that's the only issue.
Here, Lordship, the challenge of
Okay, then we give you this is 1 week means only 1 week.
Yes.
Or maybe Chief is today. Wednesday, na?
yes,
By next Tuesday. Not after the next Tuesday, the matter will be taken.
Yes. But
If you have any, your objection will be definitely.
my objection is also of them filing the whatsoever the reply they are submitting, Your Lordship. Your Lordship is well aware that there is a procedure of how the matter is to be filed, Your Lordship. They have filed our objection to our petition. We have filed a reply. Now, where is the question of filing a reply to the
Yes,
reply?
In the Lordship, the question before this Honorable Court is regarding the jurisdiction.
Yes.
Now, my contention is the HGB who has conducted this Gaba has the original jurisdiction. But they are saying that
Okay,
the
then you
complaint.
raised this issue before the court, it's at the time.
Yes.
Of
Yes,
hearing.
that's why, Lordship, the head GB, before whom his jurisdiction is lying, they participated in that Gaba proceeding. And they put their signature in the Gaba decision.
No.
Now, in their reply, they are saying that they didn't any responsibility about that Gaba proceeding.
Yes.
That's why I include the Gaba decision.
I, with due respect to this Honorable Court, Your Lordship, will see that let this matter in that case come up in the serial number, Your Lordship. The only issue is with regard to jurisdiction of the two head Gamburas, Your Lordship. The rest of the issue does not matter. The preliminary issue itself is this, Your Lordship. If Your Lordship find out after hearing the matter that they need to file an affidavit, Your Lordship can fix this matter thereafter. Because on the serious objection on my part is that how can he file an reply to a reply? The documents, if there was any new documents subsequently, when the reply was filed in the month of April, Your Lordship, they could have come. But then both the parties
They
without
brought into
any.
new document, Lordship, at least I must have an occasion to reply.
in that case, if you have, they have brought some any new documents, in that case, you make your submission or objection verbally also before this court.
Yes.
Oral submission will be, true, I think. But this process is really going on, that we will file the written of the affidavit in opposition, they will file the reply, again they will file the.
Because
reply.
if they bring up that document, we'll again file our reply.
A form of additional, whatever you like, but
Yes,
1
Lord,
month.
let's say 1 week.
Heard MST Dilanet for the petition, also heard Mr. K. Rowland, Dilanet Legislative Council for the respondent. And that after filing of their reply in affidavit, some new documents were brought in the case record, and hence he needs some more time to affidavit in opposition against LTF for the opposition. Waited till for last 10 months to submit in this regard, and by the time both the parties with the consent of the with both the parties with consent took time to several adjournment, and the neighbor raised the point that some additional affidavit in opposition or reply has to be submitted by the additional by the respondent side. In this regard, Mr. Nolan submitted that some of the documents are brought in the case record that for the respondent to furnish their reply in that regard. Otherwise, the respondent may be, there will be, fugitive may be cost to the. Considering this submission made by the Learned Council for both sides, and also considering the fact that the petition, if the petition is pending at the stage of evidence since last many occasion, I hereby instruct both the parties to go for the admission here in the next week without any fail. And Mr. the Learned Council for the respondent also hereby directed to file the additional affidavit and within honor before the next. According to listed after.
Your Lordship, if I may pray, Your Lordship, if the matter is listed on 19th of February, Your Lordship, I have some difficulty next week, Your Lordship.
12 for 13,
On 19th,
you are on 119.
yes. I'll be out of session on 12.
No, I'm going to, my intention was to fix it on either 5th or 7th. Will you be able to?
Yes, Your
Oh,
Lordship.
you
On,
can fix
yes.
it. 7th.
Your Lordship
Seventh is the-
also,
Okay, then 8, make it on 8 of February.
Your Lordship may also,
8 of February. Yes,
if the direction that, because if they are filing their additional affidavit whatsoever, Your Lordship, if it is given to me prior to the date of, because if they are giving on the date, on the same date, the matter will not be heard and
further the respondent, the counsel for the respondent, we are asked to file the copy of the additional affidavit in opposition, if any, prior to the next date of this.
yes, deeply obliged.
Item number 16 and 25.
One six.
Item number 25.
This is the hearing.
Yes.
16 is for hearing, madam, this is a long pending
Yes,
letter.
long pending. matter.
Yes.
Tomorrow I can. Tomorrow there is a hearing day, Thursday is always good. And Friday we won't take any kind of hearing, because. Now see, this is the case of 16.
That
Today I'm-
dispute
I'm-
relates to 1991, madam.
Yes,
When up to Supreme Court demanded back to the trial court again,
Ah.
is now here.
then yes.
That case, 21st of February.
21st of February. So you're appearing on behalf of T.T. Tara?
Yes.
Or Mr. Yeah? G.Bam, the learned council appearing on behalf of NPS, Mr. T.T. Tara, and also heard Mr. D. Pangin, the learned council appearing on behalf of the respondent. This is also a party.
No, my lord, item number 27.
So and so. It is
My
submitted
lord,
by the
pass-
learned, yes, it is submitted by the learned council, Mr. G.Bam, that due to some personal inconvenience, the and this council, Mr. T.T. Tara is not available in the court, and accordingly, wait for an adjournment. Raising objection, Mr. D. Pangin has submitted that the case is pending. Case is of 2016 and pending is not long, and hence early hearing is required. Early hearing is just considering the submission made by the learned council for both sides. Let the matter be listed on P1 20
21, my lord.
21 February 2024 with the direction to both the parties to proceed with the hearing on the next day without delay.
This order in item number 10 and 16. ma'am.
Hmm?
10 and 16, this same order, similar, same order. He's making a mention of item 10 also.
Then also.
10 also same.
Same.
And in 10
Parties are also
also,
same.
and 10 also you're appearing.
Yes.
10 or 10 will be
Same.
same. In that case, for the item number 10, when you want to fix it?
10, my lord,
10,
can be
11.
after 2 weeks.
After 2 weeks. Then the matter will be listed after 2 weeks in number 10. no? And now see, 11 is also which 11? Is the same out of same order and all, because then one I is there, which so and so, again, 11 is which?
Yes, yes, 11, with 11 also.
I will
It
check
is
up, my
same,
lord.
same also. Same matter, connected matter also. The
But
parties are-
in 11, item number 11, your name has not been reflected.
I will check the records, madam. Will it be after 2 weeks? I will check up the record.
11 also same, but you are not appearing in 11?
My lord, I will check up the
You have to
records. I
check
will
up
check.
it. Make it on to after 2 weeks, you will check the record and then we pass it.
Okay.
If by mistaken, the registry, your name has not been
Yes,
reflected in the
maybe.
maybe. No, just clarify the order in item number 11.
Because the parties, or respondents are different. Maybe I have not been engaged in this.
Maybe.
Yeah. But
No, you are parties in 10
then I have filed my wakalatnama.
and 11 also.
11, I see the petitioner is the same person, but the respondents are different person.
No, respondent in IA, respondents are also same. Anyway. You see the IA respondent is a different,
Yes,
but in
I will check up the record.
it's item number 11. This one is. Your in your position, yes?
This case also, was in leading counsel also, he got on, leading counsel.
Yes, he is Sita.
Letter when we started one or two,
2 weeks.
No, but I want to see the.
Maybe notice is also not heard.
Maybe. Have you taken steps? No. At the request of the learned counsel for the petitioner, let the matter be listed after 1 year. You check the matter.
Madam.
You can check.
lot of item number 25 topic. We're in Indian council office, my senior office, in the for partner with the half hour for this matter. Item number 25.
My lord, this is a bail application, my lord, and the CD has been called for, my lord. I have received the CD, my lord. But I've been informed that Mr. Tara is in a funeral, my lord. So, in a funeral. His, some of his, I think his, one of his relative has passed away. So he has informed me, therefore, my lord, if it can be fixed tomorrow, my lord. Bail hearing, my lord, because, my lord,
Because
this,
there are three matters which you have to pass the order and don't want to keep anything for the.
my lord, I understand that, my lord. Because I'm insisting, why? Because, my lord, the CD is here, my lord, and it has been adjourned for almost two.
So Tara will be available tomorrow. The two names of the other two council, name of the two other councils are also here.
Yes, also, they are there only.
Acha, presently Didi Tara.
Hard
Mr.
hours.
Had Mr. Swenson, the learned council, appearing for the petitioner and on behalf of Mr. Tikata, the learned and this council, also had Mr. Opada, the learned special PP. It is submitted by the learned so that due to some personal inconvenience, the and this council, Mr. Tara is not in a condition to appear before the court. However, the learned special PP has submitted that the case diary has already been received and accordingly they to pick the matter tomorrow. Considering the submission made by the learned council for the process, let the matter be listed tomorrow. No?
My lord,
Tomorrow is
Thursday.
and CDB detained till 1/4. Now to resolve the petition with regard to there are unrelated in the petition. You are Mr. R.L. R.L. Mr. R.L. Thangam. Learned council for the petition. As it has already been received. However, it is submitted by the learned council for the petitioner that there due to some that he wants to withdraw, intends to withdraw the petition as there are some uncurable defects in the case, along with a prayer for which are liberty to file afresh. Considering the submission made by the learned council for the petition, prayer for withdrawal is allowed, which is liberty to file afresh petition. Closed upon the
Item number 23,
20.
23, 23. Matter may be listed on tomorrow. My senior is absent due to health ground.
My lord, I think
Who
My
is your
senior-
senior?
You, Deka.
You take, no matter will not be listed tomorrow, yes?
Item number 23, I'm on behalf of the respondent side.
Respondents.
Yes, my lord, my senior is out of stations, so we are seeking for a 3 weeks time.
3 weeks. Or a request made by the learned council for self, with the matter be listed. It is.
May your Lordship. Lordship, I beg to mention item number 12. Here, the Lordship, service report in respect of respondent number 2 and 3 is still awaited. Therefore, this matter may be placed after 4 weeks,
Service report on respond number?
2 and 3.
So you want to take fresh steps or what?
And in the meantime, I will take fresh step.
Huh?
Yes, I may be allowed to take fresh step.
Sure.
Yeah.
Leave the next step.
Yeah, my lord, I'm appealing for respondent number 1, my lord.
Respond number 1.
Yes, my lord.
Not for the respond number 1, but there are 3 name of 3 other advocates are also showing. Are you there are also with you or
Yes, they are my associates, yes, my lord.
same?
Mm.
For
I'm,
two?
I'm only appearing for respondent number 1, my lord.
No, you are appearing for the 1 and other 3 advocates are also with the same.
My
for
lord,
one.
my lord.
Counter affidavit, you have not filed the counter affidavit, you want to file?
No, my lord, it's a very,
Service is still awaited for 2 and 3.
Yes.
Since long, I think they better take fresh steps.
Oh, yes.
You are Mr.
J. Karbak.
Your name is there? Whether your name is
Yes, sir. J. Karbak.
Aaron? Heard Mr. J. Kabak, the learned counsel for the petition, also heard Mr. O. Pada, the learned counsel appearing on behalf of respondent number 1. From the office note dated 25/1/2024, it is seen that the service on respondent number 2 and 3 are still awaited. And it reveals that the respondent, the notice on respondent number, the service on respondent number 2 and 3 is awaited since long, and hence the petitioner is hereby directed to fresh steps on respondent number. Respondent number 2 and 3, we have the proper and the address
Yes, sir.
in the proper, present and proper address to register AD and as well as the process. Matter will be accordingly listed after 3 weeks,
4 weeks.
4 weeks.
4 weeks. And your lordship, there is an interim order.
Interim order was there, interim order be continued till next day.
all right.
Online.
Lordship, I'd like to mention item number 20, 21, and 22. This item may be fixed after 3 weeks. Sir.
20, 21 and 22.
Yes, 20, 21, 22.
These are all hearing matters.
Yes,
You want
Lordship.
to go for the hearing.
Okay, I've taken consent from the respondent party, Lordship.
The respondent counsel will defend
Moreover,
why-
in this state, the respondent is dead, so we have to implement the other party. So we need some more time to implement the other party.
There was a sole respondent or?
Yes. Sole respondent was there, Your Lordship. After the death of the sole respondent, we have to implement the
Legal help. They
implement
have
the
to
party.
file IA. Impleting the legal help.
What was the, I mean, it was a conviction order? Or conviction or criminal case?
This is in acquittal,
Or against the acquittal order?
against the acquittal,
See, what was the section under which? it was acquitted?
138,
Huh?
138.
138.
NIA.
In that case, to otherwise to. Your good name?
M. Tangai.
Had Mr. M. Taming, the learned counsel appearing on behalf of the
Petitioner.
appellant, and also had Mr. Your name has not been reflected.
No, already reflected.
I am there, I don't know, my name is not reflected.
Also had Mr. K. Tama, the learned counsel appearing on behalf of, it was the sole respondent?
Sole respondent.
Sole respondent. Full stop. It is submitted by the learned counsel for the appellant that during the pendency of the present appeal, the respondent died and hence we want to implement the legal years of the sole respondent and accordingly there's some more time to file the required interlocutory application in that form. Thereabout, let the matter be listed. How many weeks you want?
3 weeks. Lordship.
Let the matter be, all the matter be listed after 3 weeks, enabling the counsel for the appellant to file the interlocutory application. Further, the registry will have a directive to reflect the name of Mr. Ketama in the cause list as the name has not been reflected. No, in cause list with 3 weeks.
Highly honored.
Highly honored.
Your Lordship, I beg to mention item number 5. This may fix on 21. I have already informed the other sides.
You are for the respondent,
Respondent number 2.
respondent number 2,
Yes, my lord.
Mr. Tama.
Yes, I'm for petitioner.
Why you need time?
Today I have some personal difficulties. And
You are Mr. T. Mine.
do you mind?
heard Mr. K. Dama, the learned counsel appearing on behalf of the petitioner, and also heard Mr. T. Maing, the learned counsel appearing on behalf of the respondent. However, he paid for an adjournment stating that due to some personal inconvenience, he is not in a position to go for hearing, to proceed with the hearing of this matter. As it has already been received.
Fixed date, 21. Oh, let's.
There is a interim order. Hello.
May I please, I'd like to mention item number 7. 7, yeah. In this case, on the last occasion, case diary was called for. However, I've been informed that the case diary has not come yet.
What about the AB 677?
Your Lordship, we have not received the case diary yet, Your Lordship.
You have not received
Yes,
the case.
case diary was called for.
Are you on interim?
Yes, Your Honor.
You are on interim.
Yes, Your Honor. Item may be fixed for on 19th of February, Your Honor.
No. Wait. Heard MS Swain, the learned counsel for the petition, also heard Mr. T. Hader, the learned petitioner PP, appearing on behalf of state respondent. It is submitted by the by additional PP that CD is not yet received. To stop, call for the CD. The interim order, the interim years bail order be continued till next date of listing. 19th.
19th of
On
February.
19th.
19th of February.
It will be listed on 19th of February. We'll call for the, issue reminder in that.
Yes, Your Lordship, we will send the reminder. Your Lordship.
I do oblige.
Deeply obliged.
Your Lordship, in item number 4, there was an interim, Your Lordship.
Item number 4.
For
You have put the dictation of item number 4 also. Item number 4. Interim was there. Interim be continued to next date of listing. Item number 4.
deeply obliged.
Your Lordship, I beg to mention item number 17 to 19. This is a connected matter, Your Lordship.
Item number
17 to 19. Your Lordship, this matter may be fixed after a week.
you are not interested, all the advocates are not interested to go proceed with the hearing of the old matters, na? 16, this is the matter of 16 only, others are 18 and 2. Why?
Your Lordship, the petitioner, Mr. Learned Counsel M. Saika is also absent, Your Lordship.
Our Saikya.
Saika.
May I please, Your Lordship? I would like to make correction in item number 70. Mr. Arsaki is no more in this case.
Okay.
Who is in this case then?
Mr. Kelo was there.
Oh, then K. Lolan is available.
Yes, Arsaki is no more in this case.
May I please, madam. Well, otherwise, I am the proper respondent here, madam.
Yes,
In fact,
in item number 17.
17 to 19, madam.
In all the matters.
All the matters, madam.
Yes.
I'm afraid, my lord, I'm wrongly submitted that Mr. Isaac here. I did not find him here today, that's why. But then Mr. Kato is also not here, my lord. Next week, my lord. Otherwise, I'm ready, my lord. I'm just a proper respondent, my lord.
Mr. Kato is not available. So now we want to submit anything because we are submitting on behalf of Mr. R. Saikya.
No, my lord. On my behalf.
Huh?
He's my associate.
Why you are submitting them for Mr. R. Saikya?
No, I have been informed that he is absent today, Your Lordship. But he is associate junior president right now.
Achha, then what to do?
Next week, my lord.
When you want to say that Kato is not available.
Kato is also not here, my lord. Otherwise, my lord, I am the proper respondent, my lord.
And in item number 19, most probably Mr. Kato is the petitioner.
Yes, my lord. But since it is all
And the item number 18, senior government advocate, G. Deka is there. all these matters are related?
Yes, my lord. Sure, then, my lord, next week. Let me-
In item number 17,
Correspondent one, I'm correspondent one. I'm correspondent one. In item number 19, I'm for state.
the record absence of the record matter is 17, 18, 19.
My lord.
The recording is absence, it not be also proper. Mr. Govin's absence. Your party order. Kindly continue.
Your Lordship. Lordship, this is a joint criminal petition filed by the complainant victim and the alleged accused persons. Earlier hearing, this honorable court has directed the petitioner to submit regarding the status of the case before the London trial court and to furnish the certified copy of that order. So, Your Lordship, I am furnishing the copy. On 29/11/2023, this honorable court directed the petitioner JJB, Your Lordship. Now it is at appearance stage, Your Lordship. Yes, yes. This honorable court have just earlier hearing have want to know, inquire about what is the status of the case.
The JJB pending of JJB state.
State,
And here the other
petitioner were directed to produce the status of the stage of the case. Now this
otherwise the proceeding of this present case is not stayed.
not.
So you are not appealing for JJB.
I am for the accused petitioners and the complainant. Here there was a mutual settlement between the parties.
JJB, what matter is pending before JJB?
Your Lordship, the respondents seems to have applied, made a objection for a regular trial stating that they are juvenile, Your Lordship. And therefore,
Actually, we are here, Your Lordship. This
Otherwise,
matter already.
When if the person is juvenile or if his matter is pending before the JJB, then on his behalf also, or he cannot file the petition.
Here, Lordship, charge sheet was filed against the alleged accused person. 4 alleged accused persons were there.
Out of 4 it is
all,
one was JJB.
all the accused persons were minor during the.
All were minor.
All were minors.
Then why you have come?
And this matter was forwarded before the JJB. So in between, on 2023, there was a mutual settlement agreement between the complainant victim. Now trial is at the time when already these alleged accused persons are major. During the course of this incident took place, during the course of the commission of offense.
Minor is always a minor.
Only in the last hearing, this
They are not
honorable court.
appeared before
Here, Your Lordship, 2 out of 4 juveniles the juvenile in conflict. Two have appeared and two are not at present.
Call for the LCR, Your Lordship.
Now they have become major.
They have become major and
Earlier you took the plea that they are minor, now they are major.
they are major. This now trial
So
is going.
why they are getting that opportunity of or benefit to try before the JJB if they are
No,
minor
no,
only?
during the
As
time
per
of
you, they are major, as per you, they are
during the
minor.
time of commission of this offense, Your Lordship, they were minor. And the petitioner have approached this honorable court because of that. There was a mutual settlement agreement between the complainant victim and the other.
But the mutual settlement agreement and all before the JJB court.
Yes.
Here problem is
Because
that
you
you
took the plea that they are minor, so matter has been sent before the JJB court trial. Now you are saying that they are not major and they came for an agreement. And
No,
that
you-
into an agreement.
No, Your Lordship, I want to clarify that, Your Lordship, during the time of this offense, they were minor. All of the four, there were total 4 accused persons, or alleged accused persons were minor. Then the charge sheet has been filed recently. After the charge sheet have been filed under the age of the, I'm a Bhattacharya.
A Bhattacharya.
Yes, sir.
Mr. A Bhattacharya, Dilanet counsel for the petition, also have her MSTJB, Dilanet additional PP, appearing on behalf of state respondent. As per order dated 29/11/2023, Dilanet counsel for the petitioner produced the status, case status report, and it seems that as per order dated 10/11/2023. But two of the petitioners who were appearing before the JJB, court of JJB, are still remain absent. So case record, we have to call for the case record from the JJB only.
JJB only, Your Lordship.
Call for the SCR from the JJB, so it's JJB which district?
Here itself, UPR.
JJB. See the record, no? Otherwise, see, our case is under section 392, I think.
390.
392 is.
Yes.
270.
But this
It may be minor.
minor
I
and
do not,
they have no any other criminal antecedent. Right?
That is relevant time of conflict. We may consider that also, but it will become record be.
Out of 4 accused petitioners, 2 are in abroad now. They are working, one is working at Dubai and another is at Malaysia.
So how we have.
In
obtained
fact,
the signature?
Yes, in
No,
fact,
during the-
I was,
It was during the settlement on 2023. At present,
in fact, I was,
agreement was made on 2023. Honestly.
I was, because of all those the signature verification, Your Lordship, I was thinking of that should make a prayer for their personal appearance with their card or something, identity card, because there are also some, there is something to doubt about with their signatures, Your Lordship.
And it is the fact that they are not here.
Yes, yes.
When you executed the agreement,
Agreement was executed
2023.
Yes,
2023 on
Last part-
August.
August.
August, the later
2023.
part of the 2023.
23.
Okay, call for the SCR, no need to write any.
The
Stay was.
stay maybe continue also
uh,
for the interest of
the
justice.
same order may be continued in next date of listing. Next day matter after 2 weeks.
2 weeks. Your
Next day matter after.
Okay.
Deeply obliged.
May I please, Lordship? Lordship, this is a pre-arrest bail application under section 438 of CRPC filed by the applicant Sri Sandeep Kumar Das in connection with Daporijo PS case number 5/24 under section 420 of IPC. Lordship, the allegation against the accused applicant is that the accused applicant has cheated an amount of rupees 29 lakhs from the husband of the complainant, that is Ramesh Ibia. Lordship, before going into the FIR, I would like to highlight some facts from where it is reflected that the accused person is falsely implicated in this case and the accused person is completely innocent. Lordship, the fact is that the accused person, Sandeep Kumar Das, he is a resident of Dhemaji, Jonai of Dhemaji district. He is running a furniture shop at Ruksin in East Siang district, Arunachal Pradesh. He is dealing with the selling of stone crusher and generators from Guwahati and other areas. Since he is into this selling and buying of this crusher business, one of his friend, that is Madhav Gogoi, who is the friend of accused person, and Madhav Gogoi is also friend to the victim Ramesh Ibia at Daporijo. I don't reside at Daporijo and I have no contact with the victim in this case. I have never met the victim ever in my life, Lordship. But this main accused person, my friend, Madhav Gogoi, one day in the month of December 2023, he has requested me that one of his friend from Daporijo will deposit some amount in your account number, the account number of Sandeep Kumar Das, is because he cannot receive the same amount because of some tax deduction. Apprehending those tax deduction, as such, his bank account was not updated. That's why he has requested me to give my account number. As such, being a friend, I have given my account number to Madhav Gogoi. On giving my account number, the victim, Sri Rajesh Ibia, who is not at all, Lordship, connected with me, has deposited rupees 29 lakhs as alleged in the FIR, and I have withdrawn the money and I have given it to Madhav Gogoi. This is the Lordship fact of the case, which shows that I am not connected, I am not involved in this case. Now I am coming into the FIR of the present case, Lordship. To the officer in charge, PS Dapur. Lordship.
Brought the election against you.
Yes, it,
Not against the Madhav Gogoi. As per you, Madhav Gogoi is not in the picture because in your account, the money was deposited.
yes, I admit, Lordship, I admit that money has been deposited in my account. I withdraw the account, I have given it to Madhav Gogoi. Thereafter, Lordship, what happened is that this money was supposed to, this money is deposited by Rajesh Ibia to me so that Madhav Gogoi will withdraw, and Rajesh Ibia is supposed to purchase a crusher machine from one Sri Santosh Agarwal at Guwahati. Regarding that, they have also made an agreement for sale of that stone crusher before an advocate at Guwahati. Regarding that sale deed agreement, I have also annexed in my bail application as annexure to in page number 18. This is the agreement. And here also Lordship, it is clearly written that the proposed purchase machine, that is a crusher machine, the cost of that proposed crusher machine is rupees. Yes, yes, I put on. He was also there, but since I deal with the purchase of crusher machine, Lordship, I may be given protection.
City may be called for lordship so that he may appear before the IO for this statement.
I am ready to cooperate. Till returnable, I may be protected, Lordship.
Yes, that it's not a bad act.
Lordship.
Dapo PS lordship, then
The matter will step, yes, from where it has to come.
Dapo
PS
Rejo.
lordship. Dapo Rejo is quite far from here, lordship. After 2 weeks, lordship.
No, we give a date.
Oh, lordship. 16 February.
Because as he is not under protection.
Yes,
if
Lordship.
it can be reached by 12:30, it will be okay, I think.
Then 12 lordship then, lordship.
You try over telephone also. You may-
Lordship.
May intimate then.
Lordship.
Because he is not under. So it will be on 12.
Okay, deep oblige.
Obliged.
This is a second appeal. For the substantial question of law has not been framed. Can this be, my lord, Mr. Sarkar is also not here today. Can it be after a week, my lord? I, my lord, actually prepared for the hearing matter. Yes,
Yes. You are paying for the other side. Respond.
Yes.
next week, my lord, any day. I was under the impression the hearing matter will be taken. I prepared the day to adjournment. Item 16.
No, here, the substantial question of law are not being formulated.
Not yet. No.
It is still in the admission stage.
Yeah.
So, next time,
Yes,
probably
for
that
that.
has to be heard.
Yes.
Otherwise, how it can.
Yes,
be
yes, yes, yes.
Here,
Yes.
so, you know, RSS also heard Mr. Deepangi, the land council for the applicant, and also heard Mr.
Ibam.
The land council appearing on behalf of the respondent. The request of Mr. Deepangi, the case is pending, however, it is, however, no, let the matter be accordingly listed after 1 week. After 1 week, as a date to be filled by the registry, on which day the matter may be heard on the substantial question.
Yes.
As it is seen from the record that the substantial questions are not being formulated till date.
Okay.
Please.
Well, before come to the record, what is the facts behind the case is that despite that this case has been filed under section 482 of the criminal case, because this is against the order passed by the magistrate while dealing with the 145 of the CRPC. Otherwise, this is the case purely based on the civil matter, where there is a dispute of the particular plot of the area between the two parties. Accordingly, the informant is the respondent number 2, who has report against me, complaint against me before the magistrate, and accordingly, Lordship, on the basis of that report, 145 CRPC was drawn, but that was not as per the in that particular 145 order, I was directed to vacate. Therefore, I have challenged the particular order before this honorable court by the and accordingly, that order was quashed by this Honorable Court, High Court, and redirected to maintain the procedure of 145. And in due course of the time, when 145 was disposed of, rather, my lord, the possession has been decided, I have been evicted from the case, man. Therefore, my lord, now come to the record. First of all, I will take the lordship to the,
What happened thereafter? Even after the quashing of the president and redirecting the to go for the proceeding with the proper procedure.
yes.
Thereafter also.
Thereafter,
Goes against you and
yeah,
the
yeah, that had been against me. And not only that, but I have been evicted from that area. Now, my lord may kindly come to the record for the page 28. One thing, my lord, numbers before come to the record, my lord, the private respondent are not are reluctant to come appear before this honorable court, despite of the numbers of the step has been taken. Therefore, my lord, this honorable court has passed by appointing the amicus curiae. Amicus curiae is, my lord, on that particular point to assist this honorable court that whether under 45 proceeding, 145 proceeding of the CRPC, whether this eviction can be made or not. Only to assist this honorable court on this part, amicus curiae has been appointed, my lord. Otherwise, these respondents are not deserved.
For the quashing of
Yes, Your Honor, my lord, this is quashing of the impugned order passed by the magistrate on 8/6/2021. Now, before come to the particular.
the eviction, there was the civil forum was open for you only for
Exactly, my lord. Now, civil forum is there to ascertain, to decide which land is belong to. And for
You
that,
think that you have illegally
yes,
evicted from
for that, it is to inform this honorable court. For that, I have already approached to the civil court. But what they defense they taken is that since you have already been evicted from that area, from that particular plot of land under 145 CRPC, where is your right lies? My right is questioned. And the same has been supported by the presided judge that so far the possession question of the ownership has already been decided in 145. Therefore, until and unless the order passed by the magistrate 8/6/2021 is not set aside from this honorable court, it fixed that the decision title suit has already been decided. That is the problem. Under such situation, I have been compelled to come back to this honorable court before the lordship for praying of quashing of the order whereby I have been evicted. Otherwise, always civil procedure, civil court is always there to decide. Now, lordship may come to page number 28. I will start it from page 20.
please.
Page 27. para 10. Despite of the many even in this case, but I will confine with the particular person only which is before concerned before this honorable court. My lord, para 10. Nothing in the record is found. My lord, got it? Para 10. Nothing in the record is found that any such step is required under section 145 of the Code of the Civil Procedure 1973 has been resorted by the Learned Executive Bureau, while ultimately passing the impugn order dated 29/1/2017 directing removals of the structure standing on the disputed land. Therefore, it appears from the material placed on the record that the order dated 29/1/2017 is vitiated by the non-compliance of the section 145 of the Code of Criminal Procedure 1973, and as such, this code is of the considered view that the order dated such and such impugned in this petition cannot be sustained, and hence the impugned order such and such passed by the Learned Executive Magistrate 0 is hereby set aside and quashed. However, the learned section 28 page. However, Learned Executive Magistrate 0 is directed to proceed with the proceeding in the question afresh by complying all the provision as stipulated in the section 145 of the Code of the Criminal Procedure 1973, that is recording of his satisfaction for initiation and the proceeding, obtaining written statement of the parties, recording of their evidence, etc. With the above this direction, with instant rate petition stand disposed of at the admission stage. Before that, the status quo order passed by this court earlier stand marched with this order. So till that there was a status quo. Now, Lordship may kindly come to the page number 52. This is the judgment impugned before this honorable court. And this 52. Yes.
Passed by the executive magistrate.
Magistrate. And I will take the relevant portion to the Lordship. That the page 67. And I would like to read out from the page now, para 33. I'll skip the others. In view of the above discussion, I am of the opinion, that the dispute land belong to Ngilyang Hasang Uru, and it is the possession of the Ngilyang Hasang Uru, and the respondent illegally disposed of the Ngilyang Hasang Uru on 25/12/2016 by encroaching upon their land and develop the land, thereby constructing the house and garden in violation of the status quo number such and such. Thereafter, this is the quotation of the section 145 of the PO. Thereafter, order. Lordship may kindly see the order. On the basis of the available materials on the record and after perusing of the statement of the witness, this court is of the view consider that the dispute land located at the 11 kilo to 12 kilometer BRA broad from 0 toward the upper region was under the possession of the Ngilyang Husu, represented by the complainant Siri Ngilyang Rika, before the encroachment made by the respondent Sri Tayo Biki, which is it's me, which is a petitioner before this court. Respondent Sri Tayo Biki has illegally disposed of the Ngilyang Hasang Uru by encroaching upon the ancestral forest land of the complainant by removing the Nisi Apatani boundary pillar, which was erected in 1992, demarcating the boundary between the Nisi and Apatani community. Accordingly, this court is satisfied above the discussion that the dispute is likely to be cause a breach of peace and communal tension if the wrongful possession of the disputed lands by Sri Tayobiki is not disposed of by this court. Therefore, the respondent Shri Tayobiki is hereby directed to remove the illegal structure which was erected in the disputed land in violation of the status quo of research in charge within 15 days from the issue of this order.
Allegation against you was that you violated this
Yes.
stay order and erected some construction.
Yes, that is there. Thereafter, my lord may kindly come to the page number 103, because these are the supporting materials. In continuation to that order, 103, this order has been passed, whereby I have been removed, and by this order, I have, my place, my construction has already been removed by passing this eviction order. It appears in the page number 103. Therefore, my lords, I have limited case before this honorable court that while passing the 145, my lord, the magistrate could have passed to refrain both the party. So, per my humble understanding is concerned that magistrate may report to both the parties to decide the title pertaining to the ownership of the disputed land. But this is the clear case that despite of the order from this honorable court, the same has been repeated. Rather, this time, in the second time, I have been evicted. Now, status in the disputed area is that I am no more there. But despite of that, still I have to establish my right, ownership over the disputed land. Now, taking the pretext, having the order passed by 145, which is impugned before the lordship, that order dated 8/6/2021, that respondents are taking the defense that since you have already been evicted by the magistrate, where is the question? That since you have not quashed the order passed by the magistrate. Therefore, this is the prima facie case. If this order is allowed.
By the civil court also, no?
No, civil court has not passed order.
You have not approached before the civil court.
No, your honor, my lord, I am appear before the civil court. Now the civil court is also with that pretext that since you have already been disposed.
Whether you have annexed the order of the civil court?
No,
also?
no. The civil court is that is still going on there. So
You're standing before the civil court?
No, no, your lordship.
I appear before the civil court.
What has happened in this matter is that under 145, your lordship is well aware that the title is not given only if the position is given, your lordship. Under 145, a complaint was made and a executive magistrate had initiated a proceeding under 145. In 145, when there was after all the preliminary consideration of the evidences, your lordship, calling of the witnesses, your lordship, the order was passed where he was declared to be in illegal possession, your lordship. That order was challenged subsequently by them before the court of executive magistrate. And then when the executive magistrate has upheld that order, your lordship, they had approached the sessions court under criminal revision, challenging that order of the magistrate, your lordship. Now they have come before this honorable court challenging the upholdment of the order of the sessions court, your lordship, in revision petition, your lordship. That's the case, your lordship.
We'll hear it.
Yes.
So now you are challenging the order of the sessions in revision?
No.
Yes.
Session has decided. So far, the session is
So now,
concerned.
the order was there before the passed by the session judge in a revision.
Yes.
Against the 145 proceeding, you have come before the session judge with a prayer for so and so.
Oh, yes.
And that was decided in the revision by the session.
Yes.
So against this
That is
session, you have
there.
come.
Yes.
No, I am here before the order passed by the magistrate because the The order passed
Sir,
by
I
the
can
session
say,
has been.
I can understand, but the revision was also dismissed.
Ah.
The revision petition is also dismissed.
Yes,
by
yes.
session.
On the ground
Yes.
that the session has no jurisdiction, on that mere ground,
No,
because the
Okay,
high,
we
at two. My lord and my sister VP has rightly point out that so far the argument is concerned, I am supposed to produce the document related to the title suit, which is pending before the uh, senior judge, senior division court at the 0. And I have been informed the conducting advocate that the next date has been fixed for 2nd February for the documentation and issues and documentation. So I feel it appropriate that it is my duty bound, it is that the document pertaining to the civil court should be available before this honorable court. Because so far the CD is concerned, the CD was called for that is pertaining to the 145 which was conducted by the magistrate only. Therefore, my lord, I am prepared to adjourn the matter today because
No,
I am
Your
ready
Lordship,
to vote.
I have an objection. This matter was first filed in the year 2021, Your Lordship. Now I fail to understand as what the submission that this matter is still pending in certain courts, Your Lordship. There is the LCR is here, Your Lordship. All the petitions and whatsoever orders are in the file, Your Lordship. First, this matter was under 145. It was taken up, Your Lordship. That was again challenged in the revision, Your Lordship. After revision, it is before this court that this matter is pending. This matter is pending nowhere else. Your Lordship may, otherwise the issue is very short, Your Lordship.
No way, he has not preferred any.
Title suit.
Title suit.
No. The main challenge, if Your Lordship will see, I fail to understand, if Your Lordship will see the first page of the course title, Your Lordship.
Yes.
Your Lordship will see that they are challenging this particular revision petition by the Sessions Court on the ground that it was passed ex parte, which is very clear from the record as well as the order of the Honorable Court below that they were they had participated from the very first time, very first trial.
But before the, who preferred the revision?
They, Your Lordship.
They preferred.
Yes.
And they remain absent.
No, they did not remain absent.
Oh, it was
They are
just
only
in their presence it was passed.
it was present in their presence. It was passed, and also their course title says that it was an ex parte judgment.
No, it was passed in our presence, and accordingly the order of the session judge is that session court is that we should go for the
No.
civil court, and
just
accordingly we are
small-
before the civil court at this
A
stage.
small clarification throughout this, because this case, it started in the year 2016, Your Lordship. I'll chronologically explain, Your Lordship, but the only point here is, if a person comes to the court, Your Lordship, he has to very specifically challenge whatsoever in the cause title, Your Lordship. They cannot come with such kind of cause titles saying that the judgment itself is ex parte. That is my first preliminary objection, Your Lordship. Now, if I may directly take, Your Lordship, to the impugn order that they are challenging is, I believe that they're challenging is because it's not specific whatsoever in their cause title. Your Lordship will come to page number 103, Your Lordship. This was passed by the Deputy Commissioner, Your Lordship will see. He was not the executive magistrate while deciding that case, Your Lordship will see the fourth paragraph, Your Lordship. On perusal of the records, the learned executive magistrate 0 had already ordered the respondent number so and so, thereby directing him to remove the illegal structure which was erected in the disputed in violation of the status quo order dated so and so within 15 days from issue of the order dated 8/6/21. failing which the eviction process to be initiated to remove the illegal structure without further notice. Your Lordship will see that when this matter was pending under 145, Your Lordship, they had illegally made a construction. Eviction was only with regard to those construction. Now, if I may take Your Lordship to the page number 71, Your Lordship.
Page number.
71.
Yes.
Your Lordship will see this is the judgment in the revision court. Your Lordship will see the challenge made was of the order of the executive magistrate on 8/6/2021. The next page number 72 is the chronological fact of the case, Your Lordship. Now, not going through the entire paragraphs, Your Lordship, if I briefly chronologize the sequence of the event, Your Lordship. In the year 2016, 27/12, there was a complaint filed by one individual, written complaint stating that a person has illegally encroached their community land, Your Lordship. Subsequently, there was a status quo passed in the year on 29/12/2019, Your Lordship. After this was passed and the notice were issued, Your Lordship, they had approached the Honorable High Court. That is the first order, Your Lordship. The Honorable High Court said that before passing a preliminary order, the evidence of they should be heard and their evidence may be taken. And therefore, yes, the procedure was not quashed. It was referred back saying that conduct the procedure afresh. Subsequently, there was also a complaint on 17/7/2017 by the very land is also of the forest land, and therefore they had also filed the complaint. However, that complaint was not taken into consideration, Your Lordship. Now again, they have the procedure initiated. They have filed. They have come before the High Court. High Court has stated that under 141 afresh. Second time, Your Lordship. Then subsequently, Your Lordship, when the matter was pending, there was a status quo orders for both the parties. During that time, they had constructed a they constructed a structure, Your Lordship, in that land, Your Lordship. Subsequently, what has happened was this party on 29/11/2017, that's status quo. They have again approached the Honorable High Court, and Honorable High Court had again directed for fresh procedure, Your Lordship, giving them the opportunity to be heard. So the entire procedure of the entire trial under 145 started from 6/5/2020. 5/2020. They were given chance, witnesses were examined, everything was done, Your Lordship. The evidences were called for. They have also submitted their evidence.
Twice they were given the opportunity of being heard.
Yes, yes. On all the occasion, they have only made a submission before this Honorable Court that they have not been given the opportunity. The first was the notice. Second was that they have not given the opportunity. The third was that their witnesses and evidence were not being taken by the ESA at that point of time. Subsequently, Your Lordship will see on 8/6/2021, after all the evidences were done, witnesses were taken of both the party, 8/6/2021, this, they have the court under 145 had passed an order in favor of the complainants in that case, Your Lordship. Now, if I may take to the last paragraph of the order of the executive magistrate, which is at page number 69, Your Lordship. If I may read from this last part, second paragraph, Your Lordship. Accordingly, this court is satisfied from the above discussion that dispute is likely to cause a breach of peace and communal tension if the wrongful possession of the disputed land by respondent Sri Tayo Biki is not disposed of by this court. Therefore, respondent number Tayo Biki is hereby directed to remove the illegal structure which was erected in the disputed land. Your Lordship will see in violation of the status quo order dated 29/12/2016 within 15 days. So your Lordship will see this direction was made to the respondent. Subsequently, your Lordship will also see that they have though not annexed, they have on many occasions come before this court challenging different orders or also of the police report. Lordship will see one of the CR was WPC 2022 of 2020, wherein this court opined that there is nothing to interfere with the order. And in that very case, your Lordship, the other ground that they have taken in this petition, that it's a certain village, there are those villages where those the history of the land, your Lordship, that was also dealt with. Now, when we come to the impugn order, your Lordship will come to page number, the last part of the impugn order, which is at page number 97, your Lordship. If I may read, your Lordship. In view of the above discussion, this court does not find any illegality, impropriety, or perversity in the impugn order dated 8/6/2021 passed in so-and-so by learned executive magistrate, and the same is not liable to be interfered with consequently. The present revision petition being devoid of merit is dismissed. Interim order so-and-so vacated. The parties are at liberty to raise and settle their title dispute over disputed land before the court or competent jurisdiction. Now, what they are actually agreed with this, both the court knows that they cannot give any title under 145. 145 was already decided, wherein the only order for eviction, they are agreed with the eviction order. The only, under 145, none of the magistrate can give any eviction order. But during the pendency of the CR case, and when there was a status quo order, they have erected a structure. That was the only point when the executive magistrate has stated that you have constructed built a structure there during the status quo, you remove it, and has given in 15 days to remove it. Now, since they did not remove it, they have gone for revision before the Sessions Court. After the Sessions Court upheld the order of the executive magistrate, the
not the order of eviction, it is the removal of the structure.
Exactly, your Lordship. Now, also, your Lordship will see the executive magistrate has clearly given a direction that you remove the structure. Now, why this order of the executive magistrate, your Lordship? The deputy commissioner, who on the request of the parties for execution of that order removal, had issued the order at page number 103, your Lordship. And here also it has been very clearly reflected that that structure was built by him during the pendency of the case, and that already for removal of the structure was 15 days was given for removal of the structure.
Here in
Yes,
the petition, they have challenged the order of session,
Sessions.
not against the order of the, because the order of session was passed on, when it was passed 9/7.
9/7.
After the order of the executive magistrate, they move an application for revision before session.
Yes.
And during the pendency of the sessions, definitely another order was passed by the deputy commissioner directing him to remove the structure.
No, not during pendency. After, because
After the
after the order.
Oh, it is
First-
passed on 12th of August 2021.
Yes.
The order of session was on why? 9/8. So the
9/8/21.
9/8.
Now, your Lordship will see there are differences. First, by the executive magistrate under 145 for removal, they have challenged it. They have not, till that, they have not challenged even that order before the High Court, except for in the Sessions Court under the revision. Now in the revision, he has upheld it. There is no direction as to, and in fact, there is a clear direction that if they want to go for the title, you go to the appropriate court. Now, subsequent to once, because during sessions hearing, Your Lordship, the order of the executive magistrate was stayed, and therefore the deputy commissioner did not, this order did not come into existence, Your Lordship. After the order of the executive magistrate was upheld by the sessions court, and a prayer was made for execution of the order of the executive magistrate, Your Lordship. This is when this order of 12 August 21 came into existence, Your Lordship. Now, if I may take, as I've already read out the part on the cause title, Your Lordship, I'll also, because Your Lordship is well aware, there is a specific prayer has to be made to what they are challenging, Your Lordship. If Your Lordship will come to page number 19. Their first prayer is for quashing of the order dated 8/6/2021 passed by the executive magistrate, which they have already challenged. Second is of the dismissal order, order of the Sessions Court, Your Lordship, 9/8. Third is the order of the DC Deputy Commissioner, Your Lordship.
That means he had, they challenged the order of the session, however, the prayer portion, he made all the prayer together.
Together, Your Lordship. Now, my only submission here is that this is not an illegal, this is not even order of eviction, Your Lordship. This is an order of a deputy commissioner complying the order of an executive magistrate, Your Lordship. The executive magistrate has clearly stated in her order that during the pendency of the case, or while you were under the status quo order, you have billed it and you remove it by 15 days. He did not comply, and therefore it was handed over to the deputy commissioner for removal of the same, Your Lordship. There is no illegality in such orders, Your Lordship. Deeply.
My lord, now I will insist back to my point. So far, my lord, 97 page. Here the as per the order of this order passed by the session court, whereby this is said that the in view of the discussion, that it does not find any merit illegally and impropriety and perversity in the impugn order dated 8/6/21 passed.
Yeah, your petition has been dismissed, though it was ex parte.
Exactly, my lord. Therefore, my lord, interim has been vacated. The parties are at liberty to rise to settle their title dispute over the disputed land before the court of the competent jurisdiction. Therefore, I am saying that I am already there before the competent jurisdiction.
If you have suppose, if you have already approved before the competent jurisdiction, suppose in civil forum.
Yes.
In that case also, this court will, this order of the, or this court will not help you anyway. Suppose, if you have, suppose rightly or wrongly, you have not submitted the order or any petition or whatever, the tackle suit, regarding the tackle suit. But in that case also, we have to pass, or we have to stick on the orders of the sessions, as well as you have made some other prayers also who has some relevancy in this case. But I don't think that if you have already approved before the civil forum, that is the best option opted by you, because this is the civil forum is the best with the authority concerned will be decided your right, tackle, interest, or whatever. If you have claimed the right or tackle over the land, so that will be there. But this court will pass the order accordingly. The matter you have challenged before us, before this court, what is the matter? That is all.
This.
So, relevancy of providing or furnishing the copies of the tackle suit, etc., I don't think it will not
necessary.
Any relevancy.
If my lord feel it is not necessary, then my lord, this may be disposed. So, my lord, if the matter is to be disposed of, then my lord, I may be able to reply to what you have.
Yes, okay.
Otherwise, my lord, this is the contention from the, my lord, the other side, that whether you have approached before that court or not. What the submitted by the PP is, my lord, correct? We are on the same footing, except, my lord, the concept and except the, my lord, angle is different. What my projected case is, my lord, that after passing of the order 8/6/2000 by the magistrate, I approached before the session court. And session has dismissed, uphold the order passed by the magistrate. So in view of the order passed by the magistrate, I have been evicted. Despite that, my case is still pending before the, my lord, pending before the civil court. And civil court failed to grant any injunction to that extent, only on the ground that you have already been evicted from the.
That is true, because to
So
grant,
it's just-
suppose, no, that
Yeah.
is to grant injunction. The position on who will be the, I mean, balance of convenience, etc., has to be decided while granting the injunction and all. So in that case, most the court has, is the opinion that as you have already been evicted, your right, the prayer for or your claim for right at the interest will not be extinguished. But the question is that injunction may not be the proper, maybe most probably that's part of your
Ma'am.
that may be there.
Ma'am, that is the.
Otherwise, you are at liberty, or you will be
Yes.
get the opportunity to raise your claim before the
Civil court, that is there, ma'am.
That is-
And I'm still before the civil court, which speaks, this documentation is to be going to be done by the second of this month. So why I am basically before this honorable court, what my projected case is that on the basis of order passed by the magistrate while dealing with the 145 CRPC, I have been evicted. Therefore, I have only the single question before this honorable court, that now by the submission of the PP, it has been crystal clear that I have been evicted on the basis of the order passed by the magistrate. What the magistrate was done, magistrate deal 145 CRPC. Therefore, only the question before this honorable court to ascertain, to determine is that whether while dealing with the 145 CRPC, then they are being evicted. Particularly, the matter belonged to both the private party. Had the case been attached with, my lord, the government, it would have been a different case. This is purely a civil nature. But while dealing with this, I have been evicted. Now eviction has clear beyond the doubt. I have been evicted on the strength of the pass by the executive magistrate under 145 of the CRPC. Therefore, my lord, to know the facts, this private respondent, they have, my lord, intentionally not appear before this honorable court because I have already been evicted. And here my question is that eviction should not be done. Therefore, my lord, in the outset also I have said, I have submitted that the amicus curiae is also appointed to ascertain this point only, whether during 145 there is a power granted under 145 that the person should be evicted or not. Though my case has been dismissed by the session court, but it has rightly stated that you have to approach before the dispute competent court. A competent court is the civil court.
Yes.
We are at the civil court. Therefore, my lord, my submission is that there nowhere in the 145 that the magistrate can evict the person from the disputed land while dealing with the 145 CRPC. That must matter.
Yes.
Your Honor, I am the amicus curiae in this case.
Yes.
This criminal petition has been filed on the surmise that there is violation of section 145 CRPC. Whereas it can be seen that the order passed by the executive magistrate, under 145, we know that it's only the possession that can be decided, not the title. And in this case, it has been seen that the order that was passed by the executive magistrate, that the possession was declared. Then as the learned PP has already given in details as to all the orders and all the stages that this appeal, this petition has gone through. The my senior learned counsel that he is stating again and again that the eviction was conducted under 145. It would be, we have to see the continuity of the case. As in the executive magistrate, after passing of the order, they have not removed, as the learned PP has already submitted, that the illegal structure was there. Now, this, the eviction that he is talking about is that now only one question, whether the executive magistrate can enforce his own order or not. Under 145, he can. So this is the part wherein they have only, the executive magistrate had enforced, as it has been again and again read out the orders, so I don't need to go through it again. So my humble submission as an amicus is that this petition is devoid of merit and bad in law, because in the sessions order also it is already reflected that it is not regarding the title. So if you are, you have to go to the right forum, and if they're stating that they have gone to the right forum, then because this was filed recently, so they should have annexed any, if they have, that is, as per my opinion, they have not. Other than this, they have not gone to any civil. So regarding this, here 145 has been very well, all the sections and under sections, everything has been done. There is, this has been only regarding possession, and disposition has been decided. This has never been titled, so there is no question of eviction as such. It was only that the executive magistrate has enforced its own order. That's my submission.
My lord, before drawing the, my lord, judgment.
Okay, I have heard you.
Madam, I am submitting in support of my, argument, I am submitting one citation, wherein the High Court has decided that under 145 proceeding, there no eviction can be passed by the mayor. My lord, kindly note, para number 6 and 7. Let me find.
Even if I can finish it up, if I'm reserving the order, if I can pass the order by tomorrow or by the day after tomorrow.
Oh.
Number 6.
One thing, Mr. 16, 17, and 19, time. 17, 18, 19. It calls for purpose 17, 18, 19. 17, 18, 19. You were also there in 17, 18, 19? No, ma'am. 17, 18, 19 is first point. 17, 18, 19. Do you have any other information now? 17, 18, 19. Mr. You were there, Mr. In 17, 18, and 19.
Yes, sir. Lordship,
So we'll record that, on that time we're not there.
yes, sir.
So we do not, actually, I do not want to record your absence because you were there in the morning.
Yes, yes, yes.
So now here in 17, 18, 19, Mr. Kato, most probably he is not available.
He is not available.
In 17 and 18, he is.
He is the private
appearing on behalf
respondent.
of the respondent.
Yes, Lord.
And in
And
19, most probably he is for the.
He is
petition.
representing the petitioner.
So we'll pass the order accordingly. We'll record the presence of. It will be more or less same. We'll just see. In 17, 18, Mr. Kaku, he is absent now. So the ground of his absence. And Mr. Opada, you are appearing on for? Respondent number 1. Huh? Investigate again. Oh, so special PP for SIC also, and you are for the state? In petition 18 and 17 and 18, you are for the state? Oh, you are for the state on 19? No, in 18 also there is there. 17 and 19. Mr. G. Talo is appearing for 17 and 19 for the respondent, state respondent. And special PP is appearing on 17, in 17, 18. You're not appearing on 19. No. 17 and 17 and 18, special PP, SIC is appearing. ঠিক আছে? And Mr. M. Kato is appearing for 17 and 18 for the respondent. He is absent. On his ground only, we are giving the adjournment. And in 19, Mr. Kato is for the petitioner. And Mr. G. Talo is for appearing for the state respondent. In, no, in 19. Only in 19, I think. 17 and 19. And they, you are appearing for 17 and 18, Mr. Loeng, you are appearing?
Yes, Lordship, I am in item number 17. I am
Yes.
for the petitioner.
Item number 17, Mr. K. Loeng is for this 17 petitioner.
Yes.
And
And
in
item 19, I am for the private respondent number, Lordship, 4.
In item number 19, you are appearing for private respondent number 4.
4, Lordship.
Do one thing, in item number 17, he is appearing for petitioner. In item number 19, he is appearing for private respondent number 4. But his name has not been reflected in the cause list, so ask the registry to reflect the name of Mr. Loeng. And in the 18, in 18 special PP, you are also there in 18.
I don't have, I'm not received any.
18, you are also in 18? No.
No, I'm not.
In senior government. No, but senior government advocate is for the, I think for the petitioner.
Petitioner, yes.
And Mr. Kato is also in 18. So senior government is, advocate is not here today. G Deca, name of G Deca is there. He is not the government advocate now.
Earlier,
18
it
you
was
write that,
appeared by
the petitioner,
Gothar.
the senior government. So who will appear today for the petitioner? As the senior government advocate? If anyone is there, no problem.
Earlier, government advocate Miss Gothar, that time, she was appeared.
Who was appearing?
Miss Gothar. G. Gothar.
Here. Like that, the petitioner is not represented by the any government advocate. And 18 you are not appearing, no? 18 both of you are not appearing.
Next week, today also I'm ready, but Kato is here, so next week.
Show me the orders. N. Sharma is the leading counsel.
Your Lordship,
N. Sharma is supposed to be, is not available. He's not. Date for one.
yes, Your Lordship, is set for 1.
Yeah, please. In this case, my lord, the CD it was called for.
The receipt CD?
Yes.
Basically, my lord, my humble submission. When this applicant was cooperating with the investigation officer by appearing before him on 23rd December 2023 in compliance with the section notice under section 41A. And when FIR, this applicant name is not there. And even on the inquiry report, that was subsequently treated as FIR, the name of this applicant is not there. Then how do this investigation agency, they raided the house of this applicant on 18 January 2023. So apprehending the arrest, this applicant has filed this arrest bail application on 19. Other than that, Lordship, kindly maybe taken note of. Even the sections registered are section 419, 420 IPC, read with section 66D IT Act, but it is not registered with section 34 or 120B. So therefore, Lordship, I am before this honorable court, is because I have no role in any of the whatever allegation is made. Allegation is that one Mr. Manoranjan Gogoi, Lordship. He is a data operator, contingency staff. And he, by misusing his official power, has made some voters' name enlisted in Aeronet. Aeronet is a web portal that is maintained by the electoral registration office in the office. So wherein some elector's name has been enrolled without verifying the those name by this official staff. This is the allegation. And I don't know how do I connect with this case.
So what do you do actually?
I am friend of this Manoranjan Gogoi. And when I was interrogated also on 23rd December 2023, simply the questions, all the questions that were concentrated only on the personality of this Manoranjan Gogoi, like how his family, have you visited him at Lakhimpur, or how is your relationship with this Manoranjan? So those were the questions that were put on me on 23rd. So 23rd also I appeared in compliance with notice under section 41A. So thereafter, suddenly raiding the house, so that made me to file this application before this notice.
And after obtaining the interim order, has he appeared?
24th, Lordship, I went, but OCPS Nyapin, he was there. He said that it may not be necessary to execute. I even wanted to deposit the amount, that bail amount, 20,000. So when OC has said it may not be required, so I left from Nyapin.
That means his statement is not here.
My statement is there, Your Lordship.
His statement is here.
There.
While he appeared before the IO in compliance with 41.
Yes.
41.
Yes. If I may, Your Lordship. Now the CD says otherwise, Your Lordship. If Your Lordship will see, first of all, the section 34, Your Lordship is aware that subject to the completion of investigation, that section will come into existence. Now, Your Lordship, though the FIRs, Your Lordship will come to page number 10, Your Lordship.
Page number 10 of
10 of the petition. The complainant is the ERO officer, Your Lordship will see. Though because only Manoranjan Gogoi, he was apprehended on this FIR, Your Lordship. Subsequently, on his revelation, the entire case was revealed, and therefore he was also sent notice under 41A, Your Lordship. Your Lordship will see that as per his own statement, Your Lordship, he has offered 18 lakhs by check and 4 lakhs in his account, and also participated in one of, on his request, Manoranjan Gogoi's request. He also attended some union. Your Lordship is aware that the election is very nearby, Your Lordship. For this work, because this person is the operating the DO and ERO office, and he has an ID of his own, which only he can operate, Your Lordship, and put up the name of all the voters. 700 of such illegal voter were included in the list of the electoral, Your Lordship. Now, if I have flag marked the statement of Manoranjan Gogoi, Your Lordship. Yes, he has clearly stated how much he was offered, and he was offered by none other than this Tadar Nilo, Your Lordship. He had offered him 18 lakhs by check, 4 lakhs, and subsequently 1 lakh later on, Your Lordship. Now, I've also flag marked the statement of the accused, Your Lordship, wherein he has admitted to the fact that he had come with an offer, Your Lordship. Since he is involved with certain political parties, Your Lordship, and for the coming election, he has offered this person, who is a contingency operator, Your Lordship, offered him the money, and with his help, there was 700 enrollment of the people, Your Lordship. Different for any enrollment, Your Lordship is well aware that an ID proof is required, and especially after the Aadhaar card has come, Your Lordship. Aadhaar cards were given to this person for enrollment, Your Lordship. Now, from where does this Aadhaar card comes? Whose Aadhaar cards were those? 700 of them, Your Lordship. There were other persons, Your Lordship, who were also interrogated, Your Lordship. This money, this check was sent from the sister-in-law of the brother of the accused. He has admitted himself. The sister-in-law has also admitted to the fact that they have used my firm while transaction of the 18 lakhs, Your Lordship.
Your entire transaction is around 18 lakhs.
No, 24 lakhs.
Initially 18 lakhs and thereafter 4 lakhs.
4 lakhs and subsequently 1 lakh, Your Lordship. After the revelation of his name, when under the notice of 41A was issued, Your Lordship, there is a very categorical statement made before this honorable court in the status report, Your Lordship. The submission being made that his house was raided, Your Lordship, is absolutely false. After 41A, when his statement was recorded, Your Lordship is well aware that the discretion lies with the police, Your Lordship. If his involvement seems to be very serious and there is a chance of him influencing, then they can arrest, subject to the filling up of the checklist, Your Lordship. There was no dread. Your Lordship will see the 4th page of the status report. The police has never gone to his house, Your Lordship. There is only an apprehension after getting a 41A notice and making his own admitted statement. That's when the AB was filed, Your Lordship. Now, though I leave the discretion to this honorable court for the bail, there is a specific averments being made in the status report that there are other witnesses and there is a chance that he's going to influence. But however, with regard to he has come before the IO, as far as I've been informed, Your Lordship, he has not appeared, Your Lordship. And also with regard to the bail bond, Your Lordship, if he has not appeared, Your Lordship, there is no question of him being arrested and then executing the bail bond, Your Lordship. Though I leave the discretion, Your Lordship, to Your Lordship. However, though this seems to be a very small FIR with a name of certain specific person, Your Lordship, however, Your Lordship will see that the place Nyapin is already not, since there is an election, Your Lordship, such kind of person, and they have gone to the office of the DFO. That's when such kind of happened, and they were also present while entering the name of those people, Your Lordship. a person who is so influential that he goes to the office, he meets who is already his friend, he meets a contingency worker, and in connivance with him, your lordship, they get enrolled of 700 people. Now, out of those, your lordship, there is also a question of where does this Aadhaar comes from by enrolling? How did he has not submitted any documents to show as to where the Aadhaar card as well as other IDs were, whose IDs and Aadhaar cards were there, and where did he obtain it from, your lordship?
Whose money were, whose account those were?
It was sent to the account of one Asha, your lordship.
The Manoranjan, whether he was also being paid some?
Yes, it was under his instruction that so and so person's it was transferred to so and so person who lives in Assam, your lordship. He's the person named Asha is his relative, Manoranjan, and therefore after that, 4 lakhs cash was given to Manoranjan Gogoi, your lordship. Subsequently, this person had also invited him as a chief guest, this Tadar Nilo, to Assam for certain functions also, your lordship. That's when 1 lakh also was given. There is
So Lordship, this is as per instruction received by me that on 24th he was supposed to appear before the IO, but then OC has said that it may not be required since you are cooperating with the investigation. And rest other part allegation, Lordship, I do not have any idea, but Lordship may kindly see, because this person I have stated in application also, he is a petty contractor, hardly having some amounts to run the family. So such huge amount, how do he give this amount to Manoranjan? Kindly those statement, if anything is against this person by the main accused, that we don't know, Lordship. So that may be kindly taken note of. And
But as per your statement, I think whenever you gave the statement under 141, as you have said that you were interrogated about the Manoranjan only, but there are statement reveals that how the money was given to it about 18 lakhs or something, in your own statement. Others are available. So proved by the case diary.
yes.
It's a thing is to be looked into. Yeah, evidences of the other witnesses.
kindly see the
If I
evidences of.
see that your involvement is there, and if you and that apart, there is no statement made in the note of the IO also that you have appeared before the IO on 24, but your statement was not recorded on, or your background was not accepted by the IO. That kind of statement is also not there. Whether do you have any submission, do you want to appear before the IO?
In fact, we want to. He want to appear before the IO.
Then why
That was, so in that case, Lordship, next step, maybe by extending the interim.
Because
If custodial
there's
interrogation,
no such statement that after the interim, because interim was given to you only on the with that that you will appear and cooperate the IO, and in that case, after your cooperation, if custodial interrogation is necessary, then definitely it will be a case for custodial interrogation.
Lordship,
But the question is that you have not appeared.
20,
Complying the order, you have not appeared.
24th, 24th, he tried to appear, Lordship.
No,
IO was
nothing as
told-
such. But if that's why I'm saying that if the IO has stated him not to come on 24th, that we don't want your statement anymore, why would there be an objection in the status report? They have clearly stated that.
Not IO,
and
Lordship,
in-
OCPS Nyapin. Kindly, that is my submission.
O-
OCPS Nyapin,
IO is under the OC for obvious reason, your lordship. Now, if your lordship will see that there is a clear prayer for custodial interrogation. Why? Because as he has also submitted, your lordship, that a person of his stature won't have 18 legs. So where did this money come from? Who were the one, if he's not the one, who were the one who has obliged him to do such kind of illegal activities? These are to be seen, your lordship. And it's also for election matter, your lordship will see the very intention and motive is clear.
Any other submission from you? Okay, then I'll
In
pass
that
the order.
case, Lordship may pass order by perusing the case there.
As per your submission, I also thought that the matter most probably, your, I don't know, your involvement may not be there because you have appeared before the I also, complying the 41 also.
Basically, in such type of
Reveals otherwise, that is the.
Basically, in such type of cases, applicants should be more cautious. He is in interim, then he should have made second attempt to appear before the IO.
Definitely,
But
definitely.
simply he
Because
says
that-
24th, I tried
that
to,
privilege was given to him. He should appear.
Lordship.
Or anyway, I'll pass you.
Lordship. Highly.
Your Lordship, CD was called for, and we have received the case diary, Your Lordship, the photocopy of the case diary, Your Lordship.
Is there-
Yes, Your Lordship, the photocopy of the case diary. And he's already in interim protection, Your Lordship.
He's already in interim.
Yes, Your Lordship.
Have you appeared before the IO after obtaining the interim?
Yes, my lord.
You have appeared.
My lord, on 28th of this month, I have appeared.
28th of this month, you have appeared.
Yes, yes,
Okay.
before the police station.
Cooperated him.
Yes,
Now,
And-
what was the case under section 4606, 420?
yes. My lord, this section is compoundable, already compoundable. So we have already made a complainant.
Is it
Informant.
420 is also compoundable?
Yes,
420 is
420, yes. Compoundable by a person who is complained. Yes, yes.
I don't think so. Maybe, Silo.
420, my lord, compoundable by the person cheated with the permission of the court.
Anyway, your, yes.
Yes, Your Lordship, the brief of the case is that, Your Lordship, here the owner of a land has appointed one broker to sell particular plot of land. And accordingly, that person broker has sold out that land to group of people who is the complainant, and they have purchased the land, they made the payment. But what has happened, the middleman, that the broker, he has not paid the entire amount to the owner. That is the dispute only. And Your Lordship,
Now,
the,
as per statement, whether
yeah,
it
state-
is ready.
it's a verbatim of the FIR only, Your Lordship. The same allegation, whatever has been stated, he is admitting that this, he has to pay certain amount to the owner, for which they have executed the agreement also earlier, that remaining amount he will pay back to the owner. But he is unable to manage the amount. For that, Your Lordship, he has not pay back the remaining amount. It's something is.
That, or accepted that some amount of.
Yes, yes, Your Lordship. Yes, he has admitted. So, Your Lordship, more or less a civil dispute. Why? Because, Your Lordship, here the complainant are the person who have purchased the land, and because of the non-payment of the money by the broker to the main owner, the owner is not allowing them to take possession of the land. This is the issue here. For that, they have lodged the FIR, which they have filed a complaint before the magistrate, and on the direction of the magistrate, the FIR has been registered. This is the case. And Your Lordship, it's a verbatim of the FIR only. Whatever the allegation is there is same only, Your Lordship. The amount transaction was there, amount has not been paid. For that, possession has not been given to them on a condition that when the broker pay the entire amount, they will give the possession. So it's more of a civil dispute, Your Lordship.
Hard Mr. Your Mr. K and
Nayan.
Hard Mr. K and Nayan, the running counsel for the petition of the Hard Mr. P. H. Planning Additional PP, appearing on the petition. And this is an application of petition in connection. CDC, the submitted by the running counsel for the petition that after obtaining the interim clearance bill dated 22/1/2024, he appeared before the IO and cooperated him in the investigation of this case. Further, he submitted that the entire dispute is of civil in nature and arose due to some misunderstanding. As he position can be given and your entire dispute must.
My lord, we have already discussed.
Obliged.
My appointment. My lord, this has been, the matter is come by order, my lord. Due to certain emergency for my lord, certain exigencies in the case, my lord, this has been mentioned. My lord, this is the case wherein, my lord, the impugn order is
Who is there? The private party is there.
no, my lord, private party is, my lord, denying to receive the copy, my lord. Here in this case, the private party are the, my lord, degree holder in the monition.
No, whatever. They have denied.
Yes, they have denied.
Dusty was allowed on last occasion. I
Yes,
think.
Dusty was alone, and accordingly, I went to the resident and tried to give the Dusty, but that has been.
Have you filed any affidavit in that?
Yes, in this respect, I have already filed the affidavit that the
Affidavit
Dusty
is
has
filed?
been, yes.
So how you have how you went to the house of this so and so?
Yes. Since, but they have denied. That, to that respect, I have already filed
Denied
my
to receive.
affidavit. Right. So, my lord, I'm basically here that since the execution is going on against me,
No, it
therefore,
will be a mistake. It was under our collection. We are going to hear the matter today. I'm also getting the.
So-
We will want to, we'll fix a very short date.
my lord,
This
on
time I'll admit
Monday,
the-
Monday,
admit
man,
the- Admit the petition
my lord,
and we'll give a short date.
on Monday, man, no watch.
On Monday, lots of matters have
You-
already been fixed, I think. Let it be on 6 days holiday? Let it be on 7 then. Monday must be
no
okay.
issue.
Good. I heard Mr. C. Modi, the Planet Council for the petition. From the order dated 13/12/2023, the petitioner was asked to serve the notice to Dusty Moore. And accordingly, it is submitted by the learned counsel for the petitioner that Dusty service is the notices they tried to serve through Dusty Moore, but the respondent refused to accept the same. And in that regard, he also filed an affidavit on the service of the notice to Dusty, or to the service of the notice to the respondent through Dusty Moore. From the affidavit, it is seen that the respondent refused to accept the notice, which was in earlier occasion. What was the issue? It was served through from the Dusty Moore, or otherwise
Step was taken.
steps were how
Yes.
steps was taken.
Step was taken as per the order of 18/9/2023. Therefore, another, this Dusty service was taken on. That was,
So, on the first day of occasion also, you have submitted that you want to serve through Dusty Moore.
mine.
That means you have not taken any steps to register AD. Have you taken any steps to register AD?
My lord, it was taken on the 14 December 2023. My lord, the record is with me, whether that record is reported here.
Accordingly, the petition is admitted for hearing. No, accordingly, this the matter for admission column on 7th of February 2023.
My lord, here CD was called for, my lord, on the last occasion, my lord, and
My lord, I'm extremely sorry, my lord, since there was not any specific date for since it was said 4 weeks, my lord, I could not call for the CD, my lord. I've instructed the IO, but then since the specific date was not fixed, my lord. Yeah, that's why those, therefore, my lord, may I humbly pray, my lord, when another date may fix, my lord, so that I can produce a CD, but then.
Otherwise, this is the petition, 482.
482. Because my lord, here is a
The matter is still under investigation.
But, therefore, my lord, I need to see the CD, my lord. I've communicated to the IO, my lord.
Yes.
Yes, my lord. And one more is that there is a private respondent also, my lord, and the AD card is not yet returned, my lord. My lord, I may be allowed to take the steps through the
The one
concern.
number 2 is there.
Yes, concerned police station. Jurisdiction police station, my lord.
How you study, is okay with the council for the petition. Also have to Mr. Opada, the special people, SIC, to stop. It is submitted by Mr. The special PP that CD is not received as no fix it was there, he was under confusion, and no, CD is not received.
Instead of this. My lord.
So after 3 weeks, can we fix it?
Yes, my lord. My lord.
If the same problem will be arise.
Yes, my lord. Let it be on 28th of February.
28th of February. It will be on 28th of February.
My lord.
Fix it on 28th of February for CDs, let's.
My lord, just one more prayer, my lord, that in the notice to the private respondent, instead of the special PP, my lord, can it be through the PP, my lord? State public prosecutor. Through the public
Okay, then
prosecutor.
through public prosecutor.
No, my lord, not through me, my lord.
It says the special PP case of, yes.
I'll be only, no, the CD. I'll be only calling for the CD, my lord.
You will call for the CD.
Yes, my lord.
And now the one, after a notification of the principal set, from the principal set, it
My
will
lord.
be now, otherwise, earlier we used to send the steps to registry to directly to the jurisdiction police station.
My lord.
But now it has been changed, and now the steps has to be go, or notice has to be go through the office of the learned PP.
My lord.
But if you have, why you have submitting that through a special PP?
Then it can be through the PP in the state.
It can be through PP, through PP, office of PP.
My lord.
Problem.
All right.
Definitely you will call for the CD, otherwise who will call?
My lord.